You know the drill. 15 minutes per side. Of course, you proceed first and may reserve up to 5 minutes for rebuttal. Will let me know how much time. We are using some different timers here. We don't know what we're doing, so I'll do my best.
Thank you. Thank you, Judge. May it please the court, counsel, I would first like to reserve 5 minutes of my time for rebuttal. That's the full amount. My name is Attorney Mike Callow, and I represent Charles Williams in this matter. I would first like to review with you that this is a case that was previously on appeal. It was previously overturned and returned to the trial court for resentencing. Upon resentencing, it would be the position of my client that the exact same thing happened in the trial court. It resulted in the same sentence. The only differences appear to be that the trial court this time included the statutory language in the sentencing entries. The trial court also indicated upon sentencing that upon her review of the appellate arguments that my client failed to argue that 6 years wasn't appropriate, and somehow that was persuasive to again impose the exact same sentence. We would argue on behalf of Mr. Williams that this case is very similar to State v. Bottle, and we would ask the court to remand this case again to the trial court with specific instructions to resentence Mr. Williams. It's my belief and our position that Mr. Williams deserves a sentencing hearing that prior to being ordered to consecutive time on these multiple counts and to incorporate Simon Ray number 2, prior to being ordered to serve consecutive time to his other case in Summit County, the trial court judge must engage in an evaluation pursuant to the statutory framework. There is no requirement to cite any specific language. There is no magical language required. We understand that. That's very clear in the case law. However, much like Bonnell, in this case, the judge did not engage in the evaluation that would explain to the defendant and the community why the requirement for consecutive time, not only on the case, because he had multiple charges in this case, but also consecutive time to his other sentence.
And I stop you right there.
Yes, ma'am.
Because as I read the brief, it was clear that you were relying on State v. Bonnell, but at the same time, your brief says in several places that your client is entitled to know the reasons, and Bonnell says just the opposite, that the trial court is not required to give reasons.
It does say that, and I think it's confusing when we sentence criminal defendants. What the Supreme Court is saying, and clearly, and I think consistently for a long time, is there's no requirement for a specific reason. So if judge number 1 says this is the reason for consecutive time, that may work. And judge number 2 can pick a different reason, and judge number 3 can pick even another reason. So there's not specificity required. But I think what Bonnell says is there must be an addressing of this proportionality issue. Not in any specific way, right? So it doesn't have to be a specific addressing of the issue. There's a lot of ways to get to it, but it has to be done.
But
and that's
what
the two concepts.
The statute says has to be done is the court has to make findings, right?
Well, I think what Bonnell says, and the site says, the trial court failed to address the proportionality of consecutive sentences to the seriousness of the defendant's conduct and the danger it posed to the public. And that, I think, is similar to what happened here, is that the judge failed, in the trial court, the judge failed to address the proportionality issue. I think when we look at House Bill 86, the presumption is for concurrent time. And the presumption is because of our prison overcrowding. The general policy is for concurrent time unless and except in certain situations when the judge goes out of his or her way to make certain findings. those findings have to be addressing the issues of proportionality. And in this case, there's no addressing the issues of proportionality. Defendant in this case, as well as our community, are left after the sentencing hearing all scratching our heads as to why this case isn't with the presumption of concurrent time. There's no explanation. There's a reciting of the statutory language, but there's no indication as to why that statutory language would be applicable here.
Well, there's some other recitation regarding past conduct, criminal history, committing the offense while on bond and while on post-release control. Does any of that go to proportionality?
No. And I think just like Bonnell, what Bonnell said is how Supreme Court in Bonnell talks about the trial court described the defendant's criminal history as atrocious and reviewed the pre-sentence investigation report to determine that the defendant had shown very little respect for society and the rules of society. So in Bonnell, the trial court makes those findings and then goes right into consecutive sentences. And the Ohio Supreme Court says that's not enough. If you're going to go past the presumption in the law and the public policy of concurrent sentences, you have to specifically address proportionality and determine and give the defendant notice of what that argument is so that you can challenge it. Because the presumption is in favor of concurrent time as a public policy in this state. So if we're going to do anything other than that, the statutory framework says, trial judge, you must do more. And apparently, citing criminal history as atrocious or describing the defendant as someone with little respect for society and the rules is not enough, according to the House Supreme Court. I think what they're looking for is...
Did the court here say that that the sentence was not disproportionate to the crime? I thought I read that.
The court at the end of sentencing recites the statutory language, and the statutory language has the words in it that you're describing. Mm-hmm. But there's no discussion or application. What I think should happen in this case, for the judge to go above and beyond the statutory presumption for concurrent time, I think the judge has to discuss, these are the two charges, and this is why, or this is what evidence or what argument I rely on to determine that this is unusual. This is the exception to the rule. Some sort of discussion.
But doesn't that sound like reasons to you rather than findings?
I think there has to be, according to the Ohio Supreme Court when you read Bonnell, I think there has to be some sort of discussion, some sort of evidence that the trial court engaged in that discussion, engaged in that weighing. Because remember, the presumption is for concurrent. We're saying to the trial court, you may not order consecutive except for in this limited situation. There has to be some evidence in the record so that we all, not only the defendant who has a constitutional right to know, but we all as a community should be something that we can point to say we're confident that the trial judge did that. Took it out of the statutory framework because this is the exceptional case. And I think when we read it, we don't see that.
The court says, the court finds that consecutive sentences are necessary to punish the defendant and to protect the public from future crime. They are not disproportionate to the seriousness of the conduct and the danger posed by the defendant, especially in light of the fact that this offense was committed while you were out on post-release control, and your criminal history demonstrates that consecutive sentences are necessary to protect the public in this matter. Why is that not specific?
That is the recitation of the statutory language that happens in every criminal sentencing when we go through this. That is very normal and reading right off of the sheet, so to speak. That's not an independent evaluation.
Is out on post-release control.
I'm sorry, I couldn't hear you, Judge.
Not every criminal defendant are out on post-release control.
That's correct, not every one of them. Well, let me ask the court this, which is not my role to always ask questions, but does that describe to you why these two charges should not be concurrent, or why these two charges require additional time? I mean, that's the issue of proportionality, is that someone has to address, for this criminal defendant as well as our society, why these two charges require consecutive time. And in this case, factually speaking, they're so consistent, they're so similar, possessing drugs and manufacturing the drugs. It seems to be so consistent that would not factually support such an argument. But that's the argument I think the trial court should have in the record. The trial court has the burden to go outside the rules, outside this framework, and say this is why. And being on post-release control doesn't compare those two charges. It also doesn't, to get into the second argument, it also doesn't evidence an argument as to why this case in Medina needed to be consecutive time to serve. Again, there's no discussion between the proportionality.
Let me stop you just to inform you that you are at your 5-minute mark.
Meaning I have 5 minutes left?
Mm-hmm.
Okay. I will just go quickly and indicate that the next argument I wish to quickly address is the credit for time served. I think that when this court reversed the sentence, that therefore technically he is still being held on the previous case as a found guilty but non-sentenced defendant, and therefore he continues to get credit for time served up until the new sentence when the order is again imposed for consecutive time. And that's the extent of the next argument. Briefly then I would just highlight that in this particular case, if the record is not clear for my client to be able to argue what the judge's reasons were for taking him out of presumptions for concurrent, I think that's the problem that we have to address. Is that when you and I and everyone else reads this sentencing hearing, it should be clear why the presumption for concurrent time wasn't there. And in this case, if we're all scratching our heads, then that's not sufficient enough. Thank you, and I reserve the remainder of my time.
Very well.
Good morning again, Your Honors. My name is Matthew Kernan on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. Opposing counsel, and may it please the court. I guess I want to start first because it's hopefully a shorter issue with the jail time credit issue that Mr. Callow kind of concluded with there. The facts of this case that he doesn't mention to you are that Mr. Williams was actually incarcerated in a state prison at the time that he was claiming he was entitled to credit. And the law in this matter is very well settled. Specifically, the 10th District, State of Carter versus Wilkinson, the 11th District, State versus Smith, the 8th District, State versus Smiley, 2004, 2014, and 2013, respectively, have all held the defendant is not entitled to credit under 2967-191 when they are serving a sentence or incarcerated on another offense. Here, Mr. Williams was incarcerated on the Summit County offense for which he had already been found guilty and sentenced, and we know that he was already sentenced at the time that he was claiming he was entitled to credit because he filed a notice of availability under 2941-401. So he was already serving another sentence, even if you assume that the trial court had given him a personal recognizance bond or a cash bond that he was able to meet, and he posted such bond, or he signed personal recognizance, he would not have been released from custody. The state correctional facility would have continued to hold him for his Summit County case. He was therefore not entitled to additional jail time credit. He was not only incarcerated on this offense. He was serving time on another offense. He's not entitled to credit. Unless there are questions about that, I'll shift back to the consecutive sentence issue. I think that was pretty straightforward. The consecutive sentence issue boils down to Mr. Williams' request for the court to engraft additional language to 2929-14C4 specifically. And here's why. When he says the trial court mouthed the words of 2929-14C4 but doesn't really explain why, as Judge Morgan pointed out, really what he's asking for is for the court to explain and give reasons why it's making those findings. The Ohio Supreme Court in 15CA0062 is very clear that the trial court is not required to do that. The trial court must only make the findings at the sentencing hearing and put those findings in the entry. In fact, when we were last here in front of the court on the previous appeal, 2015 Ohio 2197, a decision from June 8, 2015, that was the exact reason we were here, because the trial court had not made the findings of the first sentencing hearing when imposing consecutive sentences. We were remanded for that very reason. The other argument about the amount of time or whether or not counsel had failed to advocate for this negotiated but never accepted plea agreement, which is the basis for assignment of error number 6, that wasn't before the court. You remanded to the trial court for the limited purposes of resentencing, specifically so the trial court could either make or not make findings in support of consecutive sentence. So to the extent that assignment of error 6 or 8 specifically reference matters that are actually subject to the 2014 original sentencing, they are beyond the scope of this appeal. But what I'll say for the consecutive sentence issue is the trial court did in fact make those findings. As the court was reading verbatim from the sentencing transcript, page 20, the court made the findings under 292914C4. It specifically found, and I know we've said this before, but it bears repeating, the court finds that consecutive sentences are necessary to punish the defendant, which is the first of the flush text, and to protect the public from future crime. They are not disproportionate, this is the second part of the flush text, they are not disproportionate to the seriousness of the conduct and the danger posed by the defendant. And then the court actually goes on and gives additional specific, especially in light of the fact that this offense was committed while you were out on post-release control. And then it makes the C4, I think it's C, finding that your criminal history demonstrates that consecutive sentences are necessary to protect the public in this matter. It makes all 3 required findings under Bell. It then incorporates those findings into its sentencing entry in this case. It spills over from the bottom of page 1 to the top of page 2. Specifically, the court, it made the findings. Quote, the court hereby finds pursuant to 292914C4 that consecutive prison sentences are necessary to protect the public from future crime and to punish the offender, and the consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the conduct the offender poses to the public, and the multiple offenses were committed to one or more courses of conduct, and the harm caused by the multiple offenses committed is so great or unusual that no single prison term for any of the offenses adequately reflects the seriousness of the offender's conduct.
Well, Mr. Williams says that that's just cut and paste out of the statute.
That's all that's required. That's all that Bell requires. It's specifically held in its syllabus that a court is not required to give reasons or to explain its findings. All that is required is that the court makes the findings. There is a substantial basis for this court to look into the record and find that the findings are supported by any competent, credible evidence. You have to affirm. The House Supreme Court has specifically said that. That is your role in this appeal. The court made the findings. He doesn't dispute that. He says the court makes the findings. His argument is that the court doesn't explain why. But the House Supreme Court has said very specifically the court doesn't have to explain why. So this court, as it well knows, is powerless to countermand the decision from the Ohio Supreme Court. If he wants to pursue this argument further, he is more than able. But that's not this court's role. Secondly, the court had the benefit of a pre-sentence investigation report, which is not part of the record in this appeal. So the ability for this court to delve into the record, which the trial court had in front of it, which is referenced throughout the sentencing hearing, is limited by the appellant's failure to include it in the record. Junker and other cases specifically hold that you must presume regularity in a firm when there is no PSI to sentencing challenge. The other issue that I want to raise is the 7th assignment of error. And in that one, Mr. Williams challenges the constitutionality of consecutive sentences. I'll note first that he never made this challenge to the trial court below. It is therefore forfeited at best under McCraw, a 2015 decision from this court, in State v. Owan, the 1986 decision from the Ohio Supreme Court. The failure to challenge it and the failure to explain why it wasn't challenged probably means that it's more likely waived. And I know forfeiture versus waiver, but when you don't challenge the statute below and it's a constitutional challenge, you lose the ability to raise that argument on appeal. The second issue here I want to talk about is the statute is first presumed constitutional, and there's really no argument. There's no argument whether this is a facial versus as applied challenge. That's not clear from the appellant's brief, which is important because the argument wasn't raised below. And really the argument would have kind of weird, not perverse, but kind of unintended consequences if Mr. Williams' argument were to succeed. If 292914C4 was unconstitutional, as he claimed, the trial court would revert back to pre-amended substitute House Bill 86 law at the time, right? It would strike to the 2011 amendment to House Bill 86. Pre-2011, foster controlled, and which had struck the old 2929-14E statute, where consecutive sentences have been authorized. So what would happen is if you agreed with Mr. Williams that 2929-14C4 is presently revised and amended in 2011 is unconstitutional, trial courts wouldn't have to make findings to impose consecutive sentences. They would still have the ability, right? After Foster, they still have the authority to do that, but they wouldn't have to make findings if you adopted his argument.
So it's a situation of be careful what you ask for?
Essentially. And I raise that because, this is why challenges like this have to be made below, and that's how these things work together. But getting back to the consecutive sentence issue, if the court has any questions about the findings made or the reasoning or how Bunnell applies in this case, I'm more than happy to answer those, but I think this case is relatively straightforward. Barring any additional questions, I respectfully ask the court to affirm with the limited caveat of, obviously, assignment of error 5, the suspended versus waived fine issue. We wouldn't oppose a limited remand to correct that here.
I have a question regarding the fact that the record bears that the court considered the PSI, but it was not a part of the record on appeal. Typically, we presume regularity in sentencing, but in this case, in light of the procedural history, that the remand was specifically for the court to consider whether to either make findings or determine that it could not make findings. Could we presume regularity, or are we contradicting ourselves in terms of the remand?
I don't believe so, Your Honor, and the basis is this. The mandate from this court just sent it back for resentencing. At the resentencing, the court had the benefit of the PSI. For present purposes, in this appeal, you are tasked under 2953-08G to review the findings of the court, under Bunnell as well, to review the findings made of the court and determine if there is a basis for them. Part of the basis for those findings would be found in the PSI, which the court had the benefit of considering. It's part of the record which would substantiate the finding made. Its omission by the appellant in this appeal, well, its lack of inclusion, I guess, would be the more apt term there. My apologies. Its absence from the record of this appeal is limiting the court's ability to conduct the review necessary. So the presumption would still apply. The fact that the remand happened from the, I think it was 2014 original sentencing, where consecutive sentences were imposed but the findings were made for whatever reason, I don't think that has any effect on the presumption that would apply under NAP and all those other cases, Watson and Younger and everything else. So to that point, right, 2953-08G2 requires this court to review the sentence to determine if there is a basis for the finding. Bunnell makes that very clear. If there is any basis for it, then you must affirm it. And part of that basis is not part of this record.
And just to be clear on the question of, let's see which assignment of error this is, the one regarding the suspension of the fine, that would be number 5.
Correct.
What was your statement as to that?
It appears pretty clear from the record that at the sentencing hearing, the court intended to waive and actually used waived in its language at the sentencing hearing. I think that's cited in the state's brief to the particular page of the transcript where that happens. I think the court used an inapt choice of word in its entry when it said it suspended the fine. And obviously that has some legal ramifications for waived versus suspended. But because the court very clearly intended and actually did at the sentencing hearing waive the fine for indigency purposes, either A, under 2953-08G2B, this court could modify pursuant to Fisher and just waive it. Or it could remand for the limited purposes of the trial court issuing a non-proton entry. Now, to be clear, such a remand would not encapsulate any of the, as the state argues at least, would not encapsulate any consecutive sentence finding would not encapsulate any length of prison term determination. It would only be for the purposes of correcting the fine waiver.
And not the resentencing, just the no term.
Not a de novo, just the no pro tem, correct. That would be the state's position there, that we would not oppose a limited purpose, a very limited purpose remand for that particular purpose. To be very clear, we would not anticipate a resentencing hearing. There would be no need to bring Mr. Williams back from whatever correctional facility he's currently at to Medina County for the purposes of holding a hearing. That would happen purely administratively. That's the state's position.
Thank you.
Thank you, Your Honor.
You have a little over 3.5 minutes.
Thank you. I'd like to touch upon a couple of arguments that we've been discussing, but first I would discuss the mandatory nature of the sentence that was addressed in the brief. The way the sentencing entry reads and the way the judge imposed the mandatory term is that all the time is mandatory. I don't think that's what the statute requires. I think what the statute requires is it's mandatory to send the person to prison. That's the mandatory part. And not that every day that you sentence them to is mandatory. And that's an important practical consideration for my client, Mr. Williams, as to whether or not he needs to serve every day of that as a mandatory term, or whether the mandatory portion of the sentencing was satisfied when he was sent to prison. And now the prison system itself can apply all the various programs that are available for early release or judicial release and or parole hearings eligibility. If the term is all mandatory, he is excluded from all of that programming. He is excluded from all those early releases. If, however, the term mandatory only applies to the fact that he mandatorily goes to prison for some period of time during that range, then all that stuff becomes eligible. And that's a very important issue that I'd like the court to address.
Well, is a 6-year sentence a mandatory prison term of one of the terms prescribed by a felony of the first degree?
Felony of the first degree is typically 3 to 11 years now. But when it says mandatory, I think the mandatory requires the court to send him to prison. I don't think it makes all 6 years mandatory time. And that's the question.
So where do you draw the line?
I draw the line to say that the judge must send to prison. Because on an F1 there's a presumption, but it's not mandatory.
No, but I mean in terms of how much is mandatory, because I thought in reading your brief that you were saying that mandatory should apply only to the 4 years, the first 4 years, and then the rest is just kind of...
That's correct. In this case, 4, because the statute specifically says it raises the minimum. So you can't sentence someone on this particular F1 to 3 years. So the minimum is 4 years. And I think that's then the mandatory is. The mandatory says to the judge, trial judge, I must send him to prison for a term between these years. But the difference between 4 years, 5 years, 6 years, 7 years the mandatory doesn't apply to that. So for instance, if he was sentenced to a term, assuming he had no other issues and no other cases and no other sentences, if he was sentenced to a term of 5 years, he would have a different judicial release eligibility than if it was longer than 5 years. So the mandatory nature, I think, only applies to telling the judge it's mandatory to send him to prison for a period within the statutory framework, and in this particular case, an elevated statutory range. But that time is not necessarily mandatory. So he becomes eligible for judicial release, becomes eligible for other programming in the facility and early release processes there, because it's not mandatory for the full, in this case, 6 years. And I think that's an important issue to address in this case. The second issue I wanted to address quickly is when this court originally handled the appeal and sent it back for resentencing, I don't think that it somehow capped my client to making any arguments. I believe...
Okay, I think your time is up.
Thank you.
And this is telling us that it's up. No, actually,
And thank you for your time.
Thank you. Thank you. The court will take the matter under advisement. We will issue our opinion and send it to both sides, and of course you can check it